I'm Heather Stone, Executive Editor of the Habitat Group, publisher of legal compliance resources for New York City landlords and property managers. I'm here with attorney Eileen O'Toole, author of the New York Rent Regulation Checklist, which is being revised this year to reflect changes in the rent laws. These changes to the rent laws will be the topic of discussion at Eileen's session at the New York Real Estate Expo this October 16th at the New York Hilton. And if you own any or manage any apartment buildings with rent-regulated units, you'll want to attend this session. Eileen, tell me about some of the recent changes to the rent laws.
Hi, Heather. Thank you for having me speak today. There are a number of points that people were anticipating for a while with these changes, and one of the biggest things that was anticipated for a while and did come to pass is amendments to both the rent stabilization law and the regulations, the rent stabilization code, concerning newly created apartments, what tenant advocates may call Frankenstein apartments. They're otherwise newly created apartments. And what that is about is a change in the law, although in fact, there actually was no law or regulations on this previously. It was really all a matter of DHCR policy that would be upheld in decisions and in case law. And previously, if you had a building and you had two apartments next to each other, they were both rent stabilized, or they were, one was rent controlled and one was rent stabilized, and you wanted to take the two apartments, break down a wall, create one larger apartment, and set a new rent, you were allowed to do that. And you could set whatever first rent you wanted. There was a period where that may or may not have been subject to deregulation, but there is no more vacancy deregulation. So you would start out with a first rent, whatever you wanted to set as the first rent. And after that, that rent would be subject to rent stabilization increases. And, the flip side of that was if you had one large apartment and you wanted to break it into two apartments, you could also do that and set two new rents in the two adjoining apartments. And one of the caveat to that, which did come up in case law, you couldn't move a closet, or you couldn't move a closet wall, or move a wall a few inches and call that creating a new apartment. It had to be significant enough that it changed the parameters, of the pre-existing apartments. So what has happened now is that the legislature has put provisions into the rent stabilization law, and the DHCR has put companion provisions into the rent stabilization code that say that if you take two apartments and you combine them into one apartment, and say the rent on one of them was $1,000 and the rent on the other one was $1,000, the base rent for the new apartment is $2,000. And on top of that base rent, you can add a vacancy increase, which vacancy increases are really just the guideline renewal increases now. You can add IAI increases if any are applicable. And that's how you get the rent stabilized rent for the new apartment. And the law also says, and the flip side of that is that if you take a big apartment and split it into two, the new rents, say the bigger apartment was a $2,000 a month apartment. If you split it square footage wise into two, each one is the base rent is $1,000. But if you say it's, you've split it so that 3/4, one apartment is bigger than the other. So one takes up 25% of the old space, one takes up 75% of the old space. Your base rent is split up proportionally, based on the square footage. So this, and one of the things they specifically say in the law now, because this has been a question for a few years while this was anticipated, was what happens if one of the units is a deregulated unit? Then if you take a rent stabilized unit next to each other, next to a deregulated unit, and create a new larger apartment, that apartment is rent stabilized. They say that right in the law. Whether that changes how you set the rent by taking the two rents, for your base rent. Some people have some question about that, but presumably you do what you do with two rent stabilized apartments. The only thing you can add to the base rent, you can add whatever the current rent guidelines are for vacancy increases, which they haven't been too high in recent years. There's no more like 20 or 18% vacancy increase. It's whatever the renewal increases are. But IAI increases have been severely limited since the Housing Stability and Tenant Protection Act went into effect in 2019. And that is something that is under, right now, mid-April 2024, there's negotiation going on in Albany over some further rent law changes. And one of the things included in that is adding some more to what's permissible for IAI increases. I don't know yet which way that's going to go, but that has been one area where the owner organizations have been advocating fairly strenuously on that point, and saying that it's impossible to fix up apartments that have been subject to stabilization under one tenancy for, say, 30 years or more, and you really have to redo the apartment to make it rentable. And with the limits of how much you can increase the rent, it's just made it very hard to do that. So we'll see where that goes. But the newly created apartment restriction is something new in the law and the regulations, and it has been anticipated for a while, but it now has in fact gone into effect. So that's one of the big things. Another
something on a substantial rehab too, right?
Yeah, substantial rehabilitation is something that it's been around for a while, and like one of the reasons there's a lot of focus on the newly created apartments and on substantial rehabilitation is they were two of the only avenues left as far as owners were concerned. After HSTPA went into effect in June of 2019, and there was no more vacancy deregulation, IAIs were minimal, MCIs were greatly reduced, what you could increase the rents at. These were about the few avenues for getting deregulated apartments. And substantial rehabilitation has been part of the rent stabilization law and regulations, the code, for a long time. And what it basically means is that if you had a rent stabilized building, and after January 1st, 1974, you substantially rehabilitated the building as it's defined in the regs and under DHCR policy, the building would become permanently exempt from rent stabilization, except if somebody happened to be living there previously and lived through the rehab and remained a tenant, that person would remain rent stabilized. But once they left, the apartment would be deregulated. There was never a requirement to get approval from DHCR previously if you did a substantial rehab to the building. But if it was challenged, you would have to prove that you substantially rehabbed the building, but you weren't required previously to file an application to get approval to do it, or, having done it. And, this means that sometimes you could have buildings that were substantially rehabbed 20 years ago, and because you now decide as the owner that you're bringing an eviction action against a tenant or substantially increasing the rent because it's an unregulated apartment under the law, as you understand it, and somebody raises as a defense that I'm not exempt from stabilization, this is a rent stabilized building, and then you would have to prove that it was substantially rehabbed. But while these pending changes to the law and the regulations were out there for a long time without resolution. What was anticipated in the proposed changes was that anyone who had ever sub-rehabbed a building since 1974 would now have to file an application to get approval from DHCR. When push came to shove and the new law amendments were finalized, what has come out of that is if you start a sub-rehab after January 1st of this year, 2024, when it's completed, you have to file an application within a year with DHCR. But if you did one and it was finished in 2022 or 2023, or in 1985, you do not have to file an application with DHCR to get approval. That doesn't mean the issue won't necessarily come up because again, someone could file a complaint claiming that they're subject to rent stabilization and being treated as deregulated. Someone can raise it as a defense in a non-payment proceeding or an eviction proceeding in housing court. And what is happening outside of New York City, where you have, it's not the rent stabilization law and code, but it's the ETPA, the Emergency Tenant Protection Act, that has the same 99% of them are the same rent stabilization provisions. There are new jurisdictions, some of these upstate towns like Kingston and Newburgh that have adopted rent stabilization since ETPA now permitted upstate towns to do that, have had, from the offset, when those towns or cities adopted rent stabilization, DHCR started sending notices to owners saying, your building is subject to rent stabilization. You have to register the building as rent stabilized, by whatever date it was. And for some owners who realize that they may qualify for a sub-rehab exemption, that has prompted the filing of sub-rehab applications with DHCR. And the procedure hasn't changed for doing it. If you want DHCR to make a ruling, or have to have DHCR make a ruling that your building is sub-rehab, you have to file, they have an application form. It's basically a cover form. You check off the box that's saying this building is exempt, due to whatever. And, in the case of sub-rehab, you check off sub-rehab, and there are a number of documents and statements you have to file. The basic rule that shows up in DHCR's operational bulletin is that you have to, they have a list of 17 apartment and building systems, and you have to show that 75% of those have been replaced. If the building was commercial, totally commercial, before you made it residential as a sub-rehab, you may not have to prove all of, how much of what you replaced, because there was nothing to replace because it wasn't previously residential. There are some changes that were made in the law and the code and the DHCR procedures now. They've, as with many things, since HSTPA, the general mode for the legislature and the DHCR is to tighten rent regulation wherever possible. So they make it, it used to be if the build, to get a substantial rehab exemption, you also have to show that the building was in quote unquote substandard or seriously deteriorated condition before you did the sub-rehab. And there used to be a provision in there that if the building was 80% vacant when you started the work, there would be a presumption that the building had was in substandard condition. They've done away with the presumption. There's more focus now on proving that the building was in substandard condition, and also that you did not harass anybody out of the building to be able to do the work. And there's, I believe it's a 5-year look back period on whether the building became vacant because people were harassed out of there. There used to also be a provision in the policy statement that, or I'm sorry, the operational bulletin The former operational bulletin 95-2 has now been replaced by one 2023-3. And there used to be a provision that if you had a basis to say we don't meet all the 75% provisions of your list, there could be good cause shown to get an exception from that. They took the good cause language out of there. So I mean the operational bulletin still says that the totality of the circumstances or the whole Megillah in effect will be looked at, but it may be harder to get exceptions to the good to the rules that are in the policy in the operational bulletin if you don't fall under them. So I just from writing up DHCR decisions for the monthly LBT publication that Habitat puts out, even before these rules changed at the end of the year, there seem to be there are a lot of sub-rehab applications that get filed with DHCR, and there are a lot of rulings that have something or other in them that people will appeal. And one of the things that was coming up before they even changed the law at the end of the year, where DHCR was making rulings that said that if you bought out a tenant before you did the sub-rehab work, the building couldn't have been in substandard condition. I'm not exactly sure what the logic is there, but I remember seeing at least 3 or 4 decisions stating that last year. So and that wasn't something that was there was no law or code that was in. It just became a thing that was being applied to sub-rehab applications. So but that's I know attorneys who practice rent regulation law may be finding that they are getting more inquiries about sub-rehab applications. My office has a number of them in progress right now. So it is certainly a thing that various property owners look into, whether they qualify.
Okay, well, I know that there are a few other things that that were amended, having to do with registrations, and I'm sure we can go into more detail of those sort of changes at your session at the Real Estate Expo in October. I don't want to keep you too long, but thank you very much for giving us this rundown. And from now till October, we will be monitoring changes that come out of the state legislature and New York City Council, so we can highlight those developments as well. In the meantime, please look for the 5th edition of the New York Rent Regulation Checklist at thehabitatgroup.com. And please join us at the New York Real Estate Expo on October 16th at the New York Hilton. Thank you.
Thank you, Heather.